Good morning, Tri-Counties. I'm Mary Harmon, your 2020 Tri-Counties President. Welcome to John's Rant. This is given by John Giardinelli. He has been our association attorney since forever. He has represented us with CAR and NER, and he has also represented some of our members. As much as we love him, the purpose of classes like this one is to avoid future litigation. That being said, we are bringing this to you to provide you with valuable information during these quickly changing and challenging times. We're prepared to answer your questions. Cody Bellmeyer will be intercepting your questions, and the ones that he can't answer, he'll be passing them to John. Remember to go to Tri-Counties, tricorealtors.com. It is your resource for information. We have a resource guide we put together on the front page of the website, along with a link to the CAR COVID-19 microsite. On the education page, you will find the recorded webinars and classes Tri-Counties have held. That's where the recording of John's rants will be found. You will also find an economic forecast that is very insightful. Please check the calendar. We're updating new classes and webinars during this time. And right now, we're going to have Lori Smith. She's the Vice President of Professional Standards, and I think almost everybody is familiar with Lori. She's been the VP of Professional Standards like forever. She's going to speak to us first. Okay, Lori, it's yours.
Hi, good morning, Mary, and thank you everyone for joining us today for our legal update. I'd first like to let you know that the Professional Standards Department is continuing to process all ethics, arbitrations, mediation, and red complaints. So please don't hesitate to file if you have a concern, and you can certainly call or email me if you have any questions on how to file a complaint. One of the more common complaints we're getting right now is agents who are currently farming and leaving promo materials at the properties. Just please remember there are no face-to-face farming procedures allowed at this time. The National Association of Realtors has informed us that any timeframes for filing complaints will not be affected by the stay-at-home order. So please keep that in mind when you're ready to file a complaint. It still must be filed within 180 days from close of escrow or date of discovery. And now would be a great opportunity and a great time to take advantage of this Code of Ethics classes that are offered to you online through CAR, and also a great time to check out all the designations that you could obtain online through NAR at realtor.org. Later on, John will be talking about the COVID-related Code of Ethics violations. So I'll just finish up with reviewing some of the programs that we do have available to you as a member that you might not be aware of. One is our Ethics Advocate program. So if you need help preparing and writing up a summary for a formal disciplinary complaint, or maybe a complaint has been filed against you and you need help responding to that complaint, or maybe you would just like a realtor to attend the hearing with you, an Ethics Advocate is a volunteer member of the Professional Standards Committee, and that's someone who will help you through this entire process and help you write up your complaint if need it. Then there's a formal disciplinary complaint. We have a formal disciplinary complaint when you feel there was a violation of the Code of Ethics or MLS rules. You would first prepare your case by laying out the Code of Ethics and MLS rules you feel were violated, and then you present that case to a panel at a formal hearing. So both sides at the hearing are given an opportunity to present their case, and after listening to testimony from both sides, the panel then can impose disciplinary action if they find there is a violation. We also have our RED program. This program was created about 10 years ago, and we've had great success with this program. You can file a RED program after you've tried to resolve an issue and that maybe the other agent isn't at all, or you're just not quite ready to file a formal complaint. You can, this is a way to get a complaint resolved very quickly. The TRICO staff will reach out to the offending party and assist with a quick resolution. And maybe an example of that would be a lack of return phone call, no emails, no text back from the other party, missing paperwork that you might need in order to close your file, using another agent's photo for advertising, not presenting offers, and flyer violations. So we track all of these calls, and if we see a pattern developing, we'll take that complaint to the grievance committee for their recommendation for a full hearing. And then the grievance committee member can act as the complainant, so you don't hearing. If you have a money dispute, arbitration is the way to settle that dispute. Members can file an arbitration when there's a monetary dispute between two agents, which is usually over a commission issue. Both parties will have an opportunity to present their case to the panel, and the panel will make the final determination and issue an award in favor of the complainant. A great program that we also have that you might not be aware of is mediation between buyer and seller. So if there's a monetary dispute between a buyer and a seller, and it's over $10,000, which is usually over the return of a deposit or lack of disclosure, mediation is required in okay. So it's basically an attempt to settle this dispute between the two parties. And we have a team of experienced brokers who can help the parties attempt to reach a settlement and keeping this dispute out of arbitration. Because after mediation, arbitration between buyer and seller can become very costly. So with that, John, I'll turn it back to you for your presentation. But keep in mind, we're certainly available here to help you if you have any questions or any complaints to file.
Well, good morning, everybody. First of all, I want to thank Laura for putting this together and Mary for chairing our panel today. It's a little different than the rants that we usually do. As most of you are aware, typically I will simply record 15 or 20-minute talk on whatever topic is hot at the time. Obviously, today we're going to do something a little bit different. I am going to rant a little bit on a couple of issues, but we're going to also open it up to questions in a little while. So as Lori mentioned, please present those questions in the Q&A box. Cody will monitor them. If there's similar questions, he'll consolidate them and we'll, as a group, do the best we can to answer them. If he can, he'll answer them on an individual basis. And so let me introduce Cody first of all. Hi, Cody. Cody is an attorney with our office and has been very, very instrumental in a lot of the intellectual stuff that's been going on, been monitoring a lot of stuff, doing a tremendous amount of writing and been invaluable to me and to the associations in terms of keeping everybody moving forward. So having said that, what I want to talk about first is a couple of new forms that are going to be coming out in June. We're going to do a little bit of writing about them, but I just want to make sure you guys are aware that in June, as is typical of every June and of course every December, we're going to have a couple of new forms. And this month, or next month I should say, there's a form called the Property Visit and Open House Advisory, and that form is going to be used just typically when we are allowed to have open houses again, just to warn people about different issues with recordings, with animals on the property, and safety-related issues. One of the issues that Cody and I have been getting a lot of questions about is bringing children to open houses, which of course you don't do right now because you're not doing open houses, but bringing children to showings, don't do that. If you can all avoid it, do not bring children to showings for lots and lots of reasons, not the least of which, of course, is COVID. There's going to be a bunch of revised forms. Most of them will deal primarily with the new rent control laws, changes in the way you give notices to cure defects, pay rent, changes in terms of lease, cancellation of leases, all that. All those forms that are currently on your books and in the ZIP program are going to be revised substantially in order to take into account the new situation that we all find ourselves in. As far as the Code of Ethics, we've written an article that all of you should have gotten by now, and it is an article on the Code of Ethics. We called it Back to Basics because the Code of Ethics is basic to everything that you guys do. It is essentially the, for want of a better term, it is the basis for almost all of California real estate law. So what we did is we took those articles of the Code of Ethics that we think are going to be the most important as it relates to what you guys are going through now. We try to take a look at at how they might impact liability, which is the standard of care that you all have. And we wrote an article to that issue. For example, Article 1, we tried to break down for you all of the different issues you ought to consider when dealing with Article 1, which is the duty to protect your client. Basically, the duty to put your client's interest primary. Today, that's different than it would be under typical circumstances. Normally, those have to do with the guidance you give them on a wide variety of issues, but today, they're looking to you for questions about showings, extended closings, removal of contingencies, and so we wanted to make sure you guys understand how that works. Number one, wherever possible, everything should be done virtually. It's just not possible all the time. Obviously, inspections, walkthroughs, if there is to be one, all of those things need to be done usually personally, and if that's the case, then I cannot stress more strongly enough, take a look at the forms that CAR has produced for you. One of the problems that I'm seeing are that people are just not reading those forms. I know, Mary, you use them diligently with your transactions, and they just answer a lot of your questions. So Article 1 is critical. You protect your client, and some of the ways you protect your client is to make sure that before they go into a property, it's fully disclosed what the situation is, and there's forms for that. Article 2, don't lie. Whatever you do today, don't mislead people on anything. If you don't know the answer, you're not healthcare people. Most of you are not doctors. You're not nurses. You're not first responders. So the answer is to send them in a direction where they can get legitimate answers to a lot of their questions. I know that the other day, Cody and I sat in on a meeting, and we were asked a lot of medical questions. Well, we don't know the answer to those questions. We're not doctors. I mean, I can take a wild guess, but the reality is you got to be really careful. But use your expertise to send people to get the answers that they need, and do not lie or mislead or exaggerate or conceal anything, particularly that you're asked. And then, again, as far as the forms are concerned, if you read them, you'll see an awful lot of the questions that Lori has been sending us regarding things that the members are asking are answered in those forms. Article 3, I believe personally, and I think, Cody, you agree with me, that today more than ever, and Mary, this I'd really like you to maybe when we open it up for questions, chime in. I think more than ever, it is critical that you cooperate with other agents in these transactions. You know, the fact is you don't have courthouses to go to. You can file lawsuits perhaps, but you're not going to get them heard. So now more than ever, it is critical that you guys cooperate with each other. Article 9 comes up all the time. Make sure you put all this stuff in writing, whatever agreements you reach. Again, that's why the forms are so important. A lot of the forms will help you document whatever it is that you've agreed to with the other side in a transaction. Article 10, even though we are in a COVID-related pandemic, that doesn't mean you get to discriminate. And in tri-counties where there's such an incredibly diverse population of people from other countries and other continents, it is really critically important that you understand what the rules are relative to fair housing and the duty to not discriminate. Article 11 sort of is the don't be stupid article. It's the article that says you are to maintain the standard of care. And in that context, now is not the time to learn a new specialty. So stick with what you know. And then, of course, in your advertising, one of the things I'm sure Lori would agree with is that advertising is critical today. And in advertising, you got to be truthful. And so that's basically it for the Code of Ethics. Today is launch day for Clear Cooperation, so remember that. And go to CRMLS's website, watch some videos, understand what the rules are for both coming soon and holds. They're different now than they were Thursday. The rules went into effect on Monday, and they're starting enforcement today. If you have a coming soon, it's important that you place it in status in the right way. If you're going to place a property on what you used to call hold, that you understand how to register that property. If you're placing a property in active, nothing really changed today. Well, let's see if there's anything else I wanted to rant about. Oh, the legislature. Your government affairs people asked you to respond last week to a red alert. And I cannot stress to you how strongly you need to think about doing that when you're asked. Just because the legislature hasn't been in session don't believe that there's not going to be mischief. And one of the little items that they're dealing with is Assembly Bill 828. Some of you are aware of 828. It is a bill that, among other things, will require landlords to accept rent over a protracted, extended period of time. It will require you to reduce rent in some cases, and it is a bill that will really harm particularly mom and pop landlords. It will cause a lot of havoc. It is all about the tenant and nothing about property managers and nothing about the landlords themselves. So very, very important that you understand that just because the legislature is not in session doesn't mean that they're not out there doing their thing. And then lastly, Lori pointed this out to me, and we're seeing it in all the boards that I represent. Whenever you have situations like this, the bottom feeders are going to be out there taking advantage of the situation, whether it's a Craigslist fraud regarding landlord-tenant and properties that are allegedly available that really aren't, whether it's SBA fraud, call me and I'll be able to get your SBA loan through quicker. Those kinds of things are out there, so be very, very cautious about those kinds of issues. They're out there. The bad guys are out there. There's not very many of them, but they're out there doing harm, and if necessary, they will harm you. Lastly, is just again to cover a rumor that I heard that we dealt with, is we're hearing that a lot of the property inspectors don't want to sign the declaration form, the PEAD, and that their organization said don't sign it. That's not true. Basically, what we're recommending is that if you're going to have an in-person inspection, number one, put it on your MLS comment site. Indicate we're going to require PEADs before anybody goes into the property. Have an understanding of how that's going to be arranged. Send the form to non-realtors. Realtors have access to the forms because, of course, they have the program. Whereas non-realtors do not necessarily have access to those forms. Send the forms to whoever you're going to want to sign them. We have an ongoing dispute regarding a 1031 exchange. So not only do we have problems with one property, we had problems with two. And the realtor that I'm representing did a really fine job of getting stuff ahead of time. So when we did the walkthroughs, everybody had a packet of what she was going to require. So obviously, she and I spoke. She did a great job of getting those packets out to people so that when they entered the property for the walkthrough, everything had already been signed, everything had already been disclosed. Think ahead. Most of your showings are going to be by appointment. They should all be by appointment. And so if you're going to do that, when you set the appointment, set the ground rules. The seller should make sure everything's been opened up so that as little as possible can be touched. The seller should leave the property. The buyers who have already signed, or the other inspectors or whoever it is have already signed the PEAD indicating they don't have the virus and all of those kinds of things. And then they should not have to touch as little as possible. And then when they leave, those areas should be disinfected and you move on. One last thing in terms of hot button topics, we've been getting a lot of calls, and this has actually been a national issue regarding, well, what if somebody in the property had COVID? Well, if there's a death, we're going to be within 3 years. And so obviously if somebody did pass away tragically because of a COVID-related injury, that is going to have to be disclosed, no different than any other death in a property. And of course, in some areas that may be a bigger issue because of certain cultural concerns. If someone had the illness and recovered, then it's no different than any other illness. And so if somebody asks you, you should answer truthfully. If you know, point them to the forms that the sellers have signed, but don't overestimate or don't over-exaggerate anything. And of course, properties can be disinfected before people take possession. So we have a couple of questions. I know, Lori, you sent over a couple of questions that people had about that issue, so we can possibly cover them if we get through the questions. So I'm gonna do something that's hard for me to do. I'm gonna shut up, and I'm going to open it up for any questions that anybody has. We have a bunch of great questions that came in earlier, but Cody, are there any live questions that have come in?
Yeah, so far there's only one live question. I'll anticipate they're going to trickle in, but I guess what we'll do, I can answer this one on the text, but what I think is smart is to address late fees for landlords and tenants. Can they charge them? Can they, when can they charge them? Those types of things. And so I can jump in and answer that, and then if you want to supplement, John, that's
sure,
more than
go
welcome.
ahead.
So generally, we've seen a lot of questions about whether or not you can charge a late fee for unpaid rent, in whether that's because of COVID or not because of COVID. And I just want to point out that just a few things. One, there are a lot of situations which prevent that currently. For starters, the CARES Act, if the individual is taking a deferral under the CARES Act or forbearance, you can't charge late fee to your tenants. Two, a lot of counties are prohibiting this. So whether it's LA County, Riverside County, San Bernardino County, they're all taking slightly different stances, but some have a very strict policy or a rule that states you cannot charge late fees. And then practically, even when the courts open, typically courts are about 50-50 on this. It's kind of a toss-up as to whether they'll award the late fees. Obviously, you can claim them, but they're often, we've seen judges who will look at them and say this is an unenforceable liquidated damages provision. When that does occur, they won't award them. So in short, it depends on the location of the property and your specific situation. The default, I would say, is probably not. But that doesn't prevent you from trying to move forward with them, from assessing them, so long as it's not in violation of another law or county ordinance, and then assessing that if and when it gets to an unlawful detainer. John, do you have anything to add to that?
Just practically, that's a great answer and spot on. A couple of other things on that, and I know, Lori, you've heard me mention this before, and I think, Mary, you and I have talked about it as well. You can't do anything, frankly, right now with people that aren't paying their rent because the courts are closed. Realistically, you're probably, depending upon which county we're talking about and which area, if it's a high rent area, in other words, where a predominant number of the living units are rentals, we're probably going to see a large backlog of evictions coming up in either late May or early June when the courts start opening back up again. They're going to handle criminal first, and then they're going to start handling evictions after that. So realistically, to pile it on to a tenant who is in good faith unable to pay their rent is really, in my estimation, probably not the best business decision you can make. Secondly, if the tenant is taking advantage of the situation, and it's going to be really interesting, Mary, I think, to see what happens as of May 1st. Because in April, we saw a spike, some areas worse than others, of people that didn't pay their rent. But overall, I think the national average was about 28-30%. But in some areas, like Orange County, for example, it was less than 15%. In the Temecula area, Murrieta, it was around 10%. Now, that was at the very beginning, of course, because not a lot of people got laid off, and if they did get laid off, but now we're seeing the second wave of layoffs, and of course, people are starting to get a little edgier, getting a little more frustrated, and if we start seeing, will be interesting to see what happens on May 1st in terms of spikes. So hopefully you'll have used the forms that CAR has provided for you to give a notice to a tenant that, look, just because we're in a COVID situation doesn't mean you don't have to pay your rent. If you're in a situation where you've been laid off, or your hours have been cut back, or for example, your situation where you're on a commission income and your transactions or whatever commission issues have slowed you down, or you have to stay home because children are not in school and you don't have anywhere to send them, then yeah, you probably have a right to withhold rent. But if you're getting full salary right now and you're working, then there's no reason for you other than, frankly, just taking advantage of a situation to not pay rent, and you're making a bad situation worse as a tenant. But the reality is, as far as a remedy is concerned, frankly, Cody, I don't think there's really anything that a tenant can do, or excuse me, a landlord can do right now. The other issue is, because this is a debt, it could be discharged in bankruptcy. And so at the end of the day, we're probably going to see a spike, I don't know when, but sometime in the fall, of bankruptcies. We're going to see Chapter 7s, which is straight liquidation. Okay, so you're kicking me out. I'm going to file bankruptcy, and if I owe you for 4 or 5 months rent, bye-bye. I'm taking that debt, I'm putting it in my bankruptcy, and I'm liquidating it out. If I'm able to pay rent, but I can't pay all the rent, then I'm going to do what's called a Chapter 13, which means I'm going to start paying my regular rent on whatever the day is. And then as far as the 4 months or 3 months of arrearages, we're going to spread that out. I believe, Cody, I'm not a bankruptcy attorney, but I believe those debts can be spread out up to 5 years. And so you might as well try to work with your tenants ahead of time and figure it out. So I don't know if there's any other questions. We've got a bunch that came in earlier. So if you don't have any more questions, Cody, I can jump on those.
Yeah, we'll jump on those questions while we wait for some to come in. If you guys have questions, please put them in the Q&A box. I'm not seeing a whole lot come through. And then one other thing to note while we're working through this, and it's kind of a good transition, is if you guys are having issues with unemployment, keep in mind the Pandemic Unemployment Assistance Program kicked off, I believe, on April 28th for realtors. There's some great Q&As on the CAR website. There's a great way to walk through that with pictures and a very detailed process that you guys can also take advantage of. If you have any questions about that, you can throw them in the Q&A as well, and we'll address them as they come up. But yeah, John, if you want to jump on the questions which we received earlier, then we can kind of move on from there.
One of the things, Cody, I was reading some of the questions. Did you mention that CAR just put out a really great a Q&A and actually has a site that they can go to for information about independent contractor unemployment? So if you're in a situation, it's the first time I'm aware of, at least in my legal career, where independent contractors who don't pay into the system can actually get unemployment. So worth looking into if you're hurting for money. Yeah, let me go over a couple of these questions. Let me get the easy one out of the way first. I still see a lot of open house signs. Can I have an open house sign in front of the property that says virtual tour? Yeah, Lori, I don't see any reason. What you cannot do is a regular open house, but most of you do videos anyway, right? You guys have been doing that for years. And I don't see any legal reason today why you cannot indicate that, hey, in fact, I took a golf cart ride around my community yesterday, and I saw a bunch of those kinds of signs that said, for information, click onto this link and you can see the house. If you're interested, then you can go forward.
Yeah, excuse me. We've had a lot of questions about open house signage, and what we don't want is just an open house that says "see agent inside" or virtual tour. So if you can get the information out about the virtual tour, that's great. But just have an open house sign, I think that would be misleading to the public.
I agree. I think it would be foolish too, because if I see an open house and somebody's driving around a neighborhood, without an agent particularly, and wants to knock on the door, that would not be a good thing.
Exactly.
And in most jurisdictions, actually a violation, at least of the standard of care, if not local shutdown law. As far as other issues, it says here, how do I work with third-party vendors such as inspectors, contractors, and staging? Use the PEAD form. Again, If it's an inspection, first of all, talk to your, I know, Mary, you've had these conversations with some of the people you have listings with. Sit down and talk to them. What is it, seller, you want to do? Some people are putting their house on hold, maybe getting an extension of the listing. If that's the case, that's fine. Try to work it out. If I'm going to allow people to come into my property, what are the terms and conditions? Number one, you want an appointment. Number two, if it's a vendor, you want to make sure they've signed the PEAD. Cody made a great comment at another town hall that it's a red flag if they're not willing to sign that form, So be careful about that. And then, of course, make sure the inspector is aware of what they're to inspect. No one should go in with them, certainly not the agent. If the buyer wants to go in, only one buyer at a time. In some jurisdictions, that's all they're allowing in anyway, is 2 people per visit. If it's a repair person, is the repair essential? Is it necessary for the closing? Is it something that could be done maybe down the line where you leave a little money in escrow and do the repairs when things are a little bit freer? And then, of course, staging should be done virtually and honestly. We've been having those questions come up now for the last year or two. Any other comments? I see you have another question, Cody, so I'll let you jump on that one, then I'll see if there's anything else we can add. Anybody else? Lori, is that about right for working with vendors? Is that pretty much what you're seeing with the Code of Ethics? Yeah. Go ahead, Cody.
Yeah, so one of the questions which came up is basically related to the PUA. Do you need to put your broker's company as the employer or leave it blank when asked? Essentially, my response to that would be, don't lie, don't omit facts, if it's a partial truth, you need to put it in there. If it's information which you have, don't omit it because you're reading into it. If they're asking for something and you have the information, you need to fill it out. That would be my general go-to on that one. If you're, yeah, and we haven't personally been through that process ourselves. It's rather new, and to get into that level of the application takes a little bit of time. But I think the important part is just you're signing it, you're sending it out to a government agency. Don't lie on it. Don't omit facts. If you have it, fill it out.
And sometimes you're going to have to expand on what it is. Technically speaking, the brokerage is not your employer because you're an independent contractor.
Right.
And so while the broker may have supervisorial obligations over you, that doesn't make them, under California current law, your employer. You're still an independent contractor if 3 things exist. Number 1, you have a proper license. Number 2, you've signed a broker associate agreement. And number 3, you're paid on a commission basis. If those 3 things exist, then you are an independent contractor. And so that's technically the answer. Any other questions? Or
I'm not seeing a whole lot there. I know we have 1 or 2 more left on our the questions we received earlier. If you want to touch back on that and let some questions trickle through.
One question that I hear all the time, so it's a great question, that is that what if I'm taking all the precautions needed, but my seller still does not want me to show the property? Then don't show the property. The bottom line is you work for the seller. If, I try to think about this in terms of my own personal situation. My wife and I have decided that it's probably time that we take this big house and turn it into a smaller house because the kids are all gone and we don't. And so I thought about that. Would I want people to be traipsing through my house now? And the answer is probably not. Be very, very limited because I can't control anything. I'm not here. I'm going to be gone. I'm going to go outside. I'm either going to go on an errand, go in the backyard, whatever. And I don't know what they're doing, and I don't know who they are, and even if they've signed the PEAD. But it's going to be an individual seller's decision. If they won't allow a showing, then the showing has to be done virtually. And again, hopefully you've done a really good job of videoing, and hopefully you've done a really good job of getting that property to where people can see it the way that the seller wants. There is a form. Most of you are aware of it. It's an RLA form, RLA-RR, I think it's called. And that's a form that is a supplement to your listing agreement where your seller, where you and your seller have had that conversation. Your seller and you have talked about, how am I going to stage the property? I'm sure, Mary, you've probably talked to many of your clients using that form as a really good checklist because it covers a lot of great stuff. And then the seller is going to tell you, this is what I want. You can be honest with them and say, look, if we're not going to show the property, then the odds are it's going to stay on the market a little bit longer. Please give me a little bit extra time and maybe sign my a listing extension. But nevertheless, it's the seller's call. And then you can be honest with them about how the marketing is going to be affected by all of that. It's my property. I get to make that call. So any other comments, Cody, on that? Or Mary, I'd like to hear from you on that comment.
Well,
Because
I have a question on the virtual showings. What kind of liability, if you show and sell a house virtually, what kind of liability does that expose the agent and the seller to?
not much. It depends on how the staging was done. First of all, staging a property for showing virtually means truthfully. Obviously, that's going to be a case by case, but if you purposefully leave out areas of the house that are substandard, or one thing we saw, this was actually before all of this started. This was back last year, where an agent purposefully put small furniture to make a room look larger, right? They misled in the way they staged. Don't do that. If you're going to stage virtually, then be as truthful and complete as you can. That's, I guess, the best advice I can give. People are going to do that. And then, of course, for you, Mary, and for people that are listing property, you've got to be truthful with your seller that not everybody is going to buy property sight unseen. Although I've been reading some articles on Inman and some of the other sites that all you get that say people are actually closing transactions from start to finish virtually. I personally wouldn't do that. I've talked to Ed Zorn, who's the CRMLS attorney. He's actually done that. I've actually gone into escrow on a couple of properties virtually with the condition that I fly back to the state where these properties are located, and then the closing of the transaction is contingent upon my physical review. But that was before the pandemic. Now people are making that decision, and people have to make those choices for themselves. As we're starting to see things open up in other states, we'll see how that works out, and who knows how much longer we'll be in this shutdown condition in California. But for right now, that's the way I would handle virtual showings. You just got to be truthful and be as complete as you possibly can.
And if I can add to that briefly, even before coronavirus, the outbreak, we saw cases even as early as last year where individuals were putting heavily padded carpets and tables over sunken in and cracked tiles that were indicative of a foundation issue. I'd say, again, piggybacking on what John said, it needs to be truthful. If it's going to be a situation where you're hiding otherwise latent defects, which people would see, would know if they were walking through the property, then you might want to reassess that.
I agree. The bottom line is none of us know today. Mary, you've mentioned the word liability a couple of times. It's a great word. It's a word we hear all the time. Okay? Liability means I have fallen below the standard of care. I have a legal obligation to do something, whether it's to make a disclosure of a material fact, to tell the truth, to put my client's interest first. Realtors have all these legal obligations that are imposed on them as professionals, right? And liability means I have fallen below that standard of care for that particular obligation, and as a result, I've caused somebody financial harm, damage, could be personal injury, who knows what. If that's the case, then I'm going to be, quote, liable. And so since this is something new under the sun, we have to kind of go back on precedent. We have to kind of look and say, okay, well, what would our typical duty be? Well, if you're asked, you tell the truth. If you're aware of a material fact, you disclose it. If you have not personally verified the information contained in the disclosure, you say, this is what the seller told me. I have not verified that, which the forms kind of do for you. So again, nothing, I guess from a biblical perspective, there really is nothing new under the sun, according to King Solomon anyway. And so you want to just make sure that you think through what you're doing and that you disclose correctly whatever it is you need to disclose or do what you need to do. But boy, if you mislead somebody and it causes somebody harm, either reduced value or additional repairs or something along those lines, when we come out of this, I don't think the courts are going to be very hospitable to people that lie during this period of time. I think that you're going to be held to not a higher standard perhaps, but definitely you're going to be held to that standard of truthfulness.
Okay, John, I have another question going back to rental properties. And we touched on this lightly before the Zoom started, but for everybody else, what options does a property landlord have if they have a tenant that was delinquent prior to the COVID shutdown, CARES Act, and all that other stuff? You had a tenant that's delinquent and is taking advantage of COVID and feels that he has 12 months to pay you back.
Well, again, I know this is not what people want to hear from their lawyer or from any lawyer, frankly, but the reality is we've had these cases. Cody and I worked on a case last week where they had started the unlawful detainer before the stay orders went into effect and before the courts closed. And the good news for those particular people is that they're going to be first in line when the courts open back up again. But for right now, unfortunately, we all have a little rainfall into each of our lives. And if you're stuck with one of those tenants that's just frankly inherently dishonest, unfortunately, the state of California did not do anything to protect landlords in situations where they're being taken advantage of. They basically said all tenants are protected. There are no evictions. We're not going to make people homeless during this period of time. And the courts aren't going to be available for those situations where somebody should be kicked out. And there's really not much you're going to be able to do other than to try and work something out. And just don't panic. And whatever you do, don't overreach.
I guess, John, what my question is more to the point is that after everything's lifted and we're getting back to semi-normal and the courts are opened, they are no longer protected by COVID-19 if they were bad actors prior to
Correct.
COVID-19.
That's correct.
That's okay. So then you can go after them they can't sit there and tout to you, I'm protected, I have 12 months to pay you back. And your answer is no, because you weren't paying prior to the COVID-19.
Then it becomes a business decision, Mary. Now, let me say this again. I'm trying not to sound political, but we have seen now that the legislature, for example, has introduced AB 828, which would change my answer, because I'm not aware, as I read through 828 today, that those types of bad actors would not be protected. And they're going to be given up to 2 years, actually, to pay back arrearages.
And for the benefit,
assuming that the legislature doesn't protect those bad actors, then the bottom line is that if I owe, let's say it's $1,000 a month, and if I owed 2 months rent when the stay went into effect, I owe that $2,000 plus on a daily basis. That number is increasing if you did your 3-day notice correctly. And when the stays are lifted, I'm going to go into court and I'm going to get a judgment against you along with a writ of possession and a kick-out order. Okay, all the standard stuff that landlords and property managers are used to. Then the problem becomes practical. Will they file bankruptcy? Should I work out a deal? Let's say, for example, I've got a tenant who really is behind, and they fell behind because they had lost their jobs. Well, if you want to get them out, you can get them out. But the reality is you're probably never going to get paid back. If, on the other hand, they have a good job, they just fell on hard times, maybe what you do is you work out something that the courts would do for you anyway, which is say, pay the rent and maybe pay something toward the arrearages for some short period of time.
John, for the benefit of the people that are listening, can you give them just a little bit of what AB 828 is?
AB 828 is a bill that I don't think is constitutional. I think, Cody, you agree with me, because it does a number of bad things, but it is a very large bill that will do a whole number of things. It will require, in some cases, again, you've got to read through the bill, it would require in some areas and in some cases a reduction in the rent of up to 25%. It will require that landlords give tenants an extended period of time to pay back any arrearages. It would require that landlords, in some cases, might be obligated to remain in a hold pattern for an extended period of time. It has a number of other features. It's just a multi-layered, in my opinion, a very foolish bill, because you shouldn't be punishing landlords today for situations, because the landlords, in many cases, have not been able to work out stays of their own mortgages. They still have insurance to pay. They still have repairs to make. And so I think it's an ill-conceived bill. It's a bad business bill. It's an unconstitutional bill, in my opinion. And I believe in the opinion of the CAR attorneys. That's why there was a red alert that Tim and Christine sent out to everybody, your GADs last week, I believe it was, Laura. And so it's just a bad piece of legislation. What scares me about the bill, Mary, and this is my personal opinion, not yours, not necessarily the TRICO board of realtors, but this is my opinion, that what this bill reflects to me is an attitude on behalf of some of these legislators that simply don't understand the devastation that's being placed on landlords, small businesses. They simply don't understand. Look, there's businesses that simply aren't going to come back. There's landlords that may lose their property to banks as well. And so I just think it's an ill-conceived piece of legislation. And I have a feeling that your GADs are going to be very busy, your government affairs directors are going to be very busy advising the board of directors and the membership on other very smart, very unsmart bills that come up. I know Cody was advising me, Cody keeps an eye on employment issues, and was advising me, and I read some things about, some workers' compensation expansions that may be coming down the road. So just got to keep an eye on that stuff. That's why it's so, the members of Tri-Counties are so lucky that their board is so active politically, because I think now more than ever, it's critical that the boards of realtors act on some of this bad legislation, not just at the state level, but also at the local level. I'm pretty comfortable you guys have done a bang-up job in terms of staying in touch with all of your city councils in your jurisdiction. And I think that's more important now than ever. And we're going to see some bad stuff coming down the road, I think.
And if I could circle back just briefly to landlord issues while we're on the topic. One thing I've seen come up multiple times now is that landlords are not forgetting, but perhaps overlooking their ongoing duties for repairs during these times, whether that's internal or external. Obviously those are unique to the circumstances. You're going to have to work with your tenants to see if you can get in the property. But I've seen these situations where the landlord is mad or frustrated by the tenant's inability to pay rent, and they're refusing to do repairs on the property. And you just got to keep in mind that you still have to keep making those repairs in order to safeguard yourself.
Cody, in some instances, I would think, especially if it's a mom and pop property owner, if they're not receiving the rent, they don't have the funds to make the repairs.
Absolutely, and that is a consideration. Yeah. I'm just saying, when you get to the UD level, those are things which are going to just provide the tenant's arguments. So if you have the ability and they're making legitimate requests, make sure you're trying to comply with those to the best of your ability. I know that's not always possible, but it is an unfortunate circumstance of all this.
And Mary, you just hit on a really incredibly important issue. It's that unfortunately, and I can understand in some cases the government has stepped in and has created sort of these one-size-fit-all kinds of regulations. But the reality is, if I'm a large real estate investment trust, I probably have reserve funds available to fix issues as they come up. But if I have one or two rentals, and this is part of the income that I live on along with my Social Security, this is how I provided for my retirement, I'm treated pretty much the same in lots of ways as that big real estate investment trust. But the practical impact of you not paying me rent is that I don't have the resources available to me to take care of this. And I have my mortgage, I have my insurance, I have my property taxes, and all the rest. And so I don't know, again, depending upon where I'm located, I think some courts are going to be sympathetic to that position. And I think Cody's right, that they're going to say, well, tenant, you didn't pay, and then the landlord's going to be able to prove a hardship. But in some jurisdictions, particularly where there's strong rent control laws, where there's already, for want of a better term, a business bias in favor of tenants, you may not see that same sympathy. And so you've got to be really, you got to think through this stuff, maybe talk to your lawyer, talk to whoever you need to talk to, and work it out. But it's going to be a case by case. I really feel very strongly that that's going to happen. And then, of course, we'll throw in, for good measure, bankruptcies and all the other stuff.
Well, I think you have to be sensitive to anything pertains to health and safety. It's a no-brainer. It's something that has to be addressed.
You start with the proposition that just because there's a COVID-19 situation doesn't give me a blanket right to not pay my obligations. That's number one. Number two, if I am in a hardship situation as the debtor, whether it's my mortgage or whether it's my rent, then you go in and you say, okay, I've been protected along with the deadbeats, but I've been protected. And now, landlord, there's a form, as you know, guys, there's a form that says, let's work it out. What's going to be our deal, right? In some cases, we've seen landlords say, I'll tell you what, if you can pay 80% of your rent, I will take that as full payment. Other landlords are saying, you know what, I'll tack on the arrearages and you have 6 months to pay it back plus your regular rent when you go back to work. It depends. It presupposes good faith. But where you have that small group that's going to take advantage of a bad situation and make it worse, then those are the same people that are going to go hire lawyers and sue that landlord because they have no pocket and the landlord allegedly will have the deep pocket. And that's going to be sorted out when all this comes down. Do we have any other questions? Because I have a great question that comes up all the time that Lori sent me. So I'd like to ask you, we got about 6 minutes. So
I'm not seeing any other questions. So
all right,
why don't you move on to
this
that one?
question for an agent whose buyer wants to cancel due to coronavirus, but has removed all contingencies. The contract was not contingent on them losing money due to coronavirus. How should the parties proceed? Well, there's basically a couple of choices, right? You can extend the escrow. You can cancel the escrow and not return the deposit and hope that the courts will agree with you that the contract will prevail and the tenant loses their deposit. Or you can throw the dice and hope that the courts will take that position, because the courts are going to be looking at some of these issues and say, well, wait a minute, Mr. Seller, how did you expect the buyer to close on time when the lender couldn't get documents done in time, appraisers couldn't get out to the property, you, seller, would not allow people in the property? So there's going to be a wide panorama of issues. If you were in escrow when all this started, hopefully you've been able to use the coronavirus addendum and figure it out with cooperation as to how you're going to handle these things. If these issues came up after, in other words, you went into escrow after the pandemic issues came about, hopefully you were smart enough to include that, that coronavirus addendum and made it part of your contract as to what will happen if impossibility of performance becomes prevalent. Again, some of the issues that we've not seen before in real estate, or rarely see, are there is no force majeure or act of God clause in your standard RPA. And so the coronavirus addendum is, in essence, CAR's excellent attempt to create that force majeure agreement. But it's still going to provide for cooperation. Again, you know, you're going to have to work it out, because is the buyer not wanting to close because they just don't want to close? Is there legitimate reasons for closing, such as is some intervening act that's made it impossible? And so work it out. Or you'll make Cody and I a lot of money when all this is said and done, because we're going to have a ton of litigation to have to deal with. And rather than deal with it through lawyers, I think the prudent thing would be to try and work it out amongst the agents and the buyer and the seller. And then at the very core, Lori mentioned at the beginning, Pacific West and Tri-Counties have a phenomenal mediation service that both associations can avail themselves of. Tri-County has great mediators available to the members. Mary, I think you're one of them. I'm not sure, but I know that there have been a ton of great mediators, Mary Ann Prophet, Larry Black, people like that can mediate for you and help you settle those disputes where maybe a neutral pair of eyes is looking at the situation. So if you have to, go mediate. Maybe talk to an ombudsman, talk to somebody that can sort of facilitate the transaction for you and try and guide you. Otherwise, you're going to be spending money on lawyers, and we're okay with that. I just don't think that that's really what you want to do. There's one last question, and then we'll close it out.
Okay, so the question is, what precautionary steps need to be taken if the listing property is a vacant property? And they clarify, besides signing the PEAD. So
limit, first of all showings, including those that are vacant, should be only to people that are legitimate potential buyers. So either they've already signed a contingent offer to buy the property, like I did some months ago, or they've pre-qualified. So don't show the property to looky-loos, number one. Number two is, again, control the showing. First of all, as Cody mentioned, the PAD form should be signed. Limit the number of people that can go in and limit what they can touch. And then if there are things in the property, doorknobs, things like that, disinfect afterwards. That's the simple answer to the question.
all right. It looks like that's all the questions we have. Does anyone have any last comments? Mary, John, Lori?
Mary, how about you? You're the boss.
I would just say major CYA, everybody. I mean, that's the biggest takeaway that you can take, is just cover your behind. I'm trying to be politically correct here. Big time. If you disclose, you're not going to get in trouble. And CAR, Tri-Counties, is providing the forms that CAR has vetted for you to protect you and to protect your clients. So if you use the forms, it should keep you out of trouble. And if you communicate. Do not ignore a text or a phone.
Absolutely.
If your agent is calling you, call them back right away, even if it's to tell them you can't talk right now, but just respond at least. And if you communicate, it'll keep everybody out of trouble. That's the biggest thing. So
I couldn't agree more, Mary. I think that today more than ever, you guys are professionals, right? I'm going to rant for just a second. You guys are professionals. And as professionals, people are looking to you the same way you would look to your doctor for guidance, or to your lawyer for legal, or anyone else. They're looking to you. And those people that like to play games, like to try and stack the deck in their own favor, now is probably not the time to do that. Lori, do you have any last minute comments?
Yes, I just remind everybody, today is the Clear Cooperation Policy going into effect. Visit crmls.org. They've got a great video you can view, and also a lot of Q&As that they'll answer all your questions. But it's incumbent upon you to be familiar with that rule before you get fined because of it. There's a lot of changes that you have to be aware of.
Right.
One more thing. We also have, CAR has a legal hotline that all the members can utilize. So if you have any questions, any issues that you're concerned about, you have that legal hotline available to you. I mean, I can't say enough or stress enough that you have so many tools available to you to protect you and your clients, to keep you out of trouble, because we just can't, I mean, just send John on another trip here, okay?
Not for a while. Apparently, I'm not going to be able to fly or go on a cruise ship for a long time. And I agree with, in fact, let me take it one step further. It's going to be my closing comment. Because you guys are members of Tri-Counties, and because Tri-Counties has done such an incredible job of putting stuff on their website, my advice is, I think that should be your first visit in the morning and your last visit at night, is go to the website, see what they're posting, see if there's anything new. Read, because what the staff has done and what Mary and her board has done and what Laura has done is to just get you the information. We can't make you read it. Can't do that, right? Not going to call you and read you this stuff. You've got to take the initiative to do that. But what they're doing between their Gads and Lori, and we're putting stuff on, and we're going to continue to do that, and Lori's continuing to do that, and Laura's doing that, is they're throwing as much information as is coming to them. It's a great clearinghouse for good information on important topics. Click. You know, it should be your one-stop shop for great information to keep you current, because we're starting, again, what the rules were yesterday are not necessarily what they're going to be tomorrow. And as we start transitioning into the next phase of this, whatever it might be, I'm not sure the government knows what that is yet. You're going to need to keep up. Stay-at-home orders are transitioning. Things are opening up selectively, all this kind of stuff. And realtors are, as an essential service, are going to be part of that mix. So go to the board. Start with Tri-Counties. That should be your first place to go. Click on, find out what you need to know, and then do whatever you need to do during the day. All right. I think I've ranted enough. Look forward to getting back to some semblance of normalcy. But in the meantime, thank you, Mary, for allowing us to do this. Laura, thanks again, and for the great job you guys do, both you and Lori Smith. And Cody, thanks again for just being part of all this. Really appreciate it.
Yeah,
So
thank you,
anything else?
Thank you, John and Cody.
Okay, guys, time to leave the meeting.
All right. Everybody,
Click. Ready to click? Click.
okay.